Hi, hello, and welcome back to this conference on disability and rights under neoliberalism. My name is Ioana Cerasera-Kish. I use she, her pronouns, and I will be chairing the second panel of the conference, second session, entitled For and Against Rights, Legalism and Resistance under Neoliberalism. As a visual description of myself, I am a white person with long red hair, and I'm wearing glasses and an orange top with white stripes. Behind me, there is a white background. As you will have noticed on the program, we had planned to host two presentations as part of this session. Unfortunately, we were informed yesterday that our guest presenter, Lara Montesinos-Coleman, could no longer join us. So this session will focus on the second presentation, which means that we will have more time for a detailed discussion during the Q&A session. Now I am delighted to introduce our presenters, Lizzie Hughes and Jenny Logan, who will be sharing insights through a presentation entitled Against Rights, Critiquing the Contemporary Neoliberal Management of Difficult Mental Health. In terms of bios, Lizzie Hughes is a postdoctoral researcher studying British anti-trans discourse and the informal surveillance of bodies in everyday spaces. Their interests include trans, creep, and critical race studies, the prison, and theories of surveillance and governance. They also run a community-based LGBTQI+ mental health project that enriches their academic research and pedagogical practice. Next, Jenny Logan is an attorney and holds a PhD in law from Birkbeck, University of London. She teaches law and legal theory at the Brooklyn Institute for Social Research and at SOAS, and is currently working on a book about the political economy of sexual violence in the United States. The presentation will last about 20 minutes, and then we'll have some time for a Q&A. And I'm just going to run through some housekeeping in case this is the first session you're joining us today. Firstly, please mute your microphone so that our presenters aren't interrupted. If you'd like to ask the presenters a question, please post it in the Q&A box. You can find this at the bottom of your screen where there is a button saying Q&A. It might be under the More button or just it might be visible already. I and my co-chair will be keeping an eye on questions as they come in, and will put as many of these to our presenters as we have time for. Please specify who your question is for, and we will not read out who the questions are from, so your information won't be shared on the recordings later. If you're unable to type and need to ask your questions directly, please raise your hand after both presentations. However, please only do this if the Q&A box is inaccessible to you, and please try to keep your questions as short as possible. We are recording these sessions, so if you choose to ask your question directly, you'll be recorded, and we'll assume that you're happy for us to share your question as part of the recording, unless we hear from you directly immediately after the conference. Then, of course, the usual applies. Please keep questions respectful and inclusive so we can enjoy exchanging ideas in a safe space today. Please do not use the Zoom chat during the presentations. This is because guests using screen readers will have your chat comments read out and will be unable to hear the speakers. So this is really important. Just to reiterate, all questions will need to go in the Q&A box, not in the chat. When you contribute verbally, please speak slowly. And finally, we have people on hand if you're having tech issues, so please send a direct message to our tech colleagues, Nell or Steve. And with that out of the way, I'll invite our presenters to share their presentations with us.
Great, thank you for that introduction. I'm just going to share our slides. Okay, so I am Jenny Logan, and my colleague Lizzie is here as well, and we are speaking, the title of our talk is Against Rights, Critiquing the Contemporary Neoliberal Management of, quote, difficult, unquote, mental health. This is very much a work in progress, so we do welcome your feedback and thoughts. It is not funded research or PhD research. It's just something that Lizzie and I came together to try and think through. And so we do welcome your comments and questions. Okay. So the structure of our talk, I think since we've been introduced, we might not say much more about ourselves other than I will describe myself now. I'm a white woman with brown hair wearing a black and brown dress. Um, so we will, maybe Lizzie wants to say a bit about themselves, but we will introduce also the terms that we are using throughout this talk. And then we will sort of switch back and forth, presenting first the carceral approaches to mental health. And then we'll present a case study on community treatment orders in the UK. Then we will talk about the CRPD, or the Convention on the Rights for Persons with Disabilities, and the limits of rights, and we'll conclude by talking about alternatives. So I think with that, I will hand it over to Lizzie.
Yeah, thank you, Jenny. Is my technology working okay? Yeah, cool.
Yeah.
Yeah, so for visual description, I'm a white person with shoulder length black hair and a white t-shirt. And then my background is extremely colourful. So we're starting from the obvious point, but it's worth stating that everyone has mental health and that everyone is likely going to experience some kind of irregulation or stress in relation to that mental health. And we don't mean that in a liberal, moderate sense, because of course, how we have and how we experience that mental health and then how that mental health is responded to differs according to a subject's context. But nevertheless, the point stands that we all experience some kind of mental health trouble at some point in our lives. And there are various ways of kind of bringing this to light. For example, the British organisation Hearing Voices Network, in their training, they run an exercise that points out the ways in which we also all experience auditory hallucinations. So, hearing a notification on your phone when it didn't actually make a sound. And again, pointing this out isn't to neutralize the experience of living with things like continuous, unusual auditory information or visions, but it's to highlight that the binary of us and them and well and unwell is far less solid than we might think. The imagined average person isn't going to think of themselves as hearing things. That's something that we're encouraged to think happens to other people and is a sign of madness or unwellness. And that's pretty much baked into how statutory bodies and large-scale charities approach mental health. The system is that the unwell service user comes to the well worker who can then relay treatment. And even in what is now quite trendy term within charities of co-production models, the final say, sorry, still lies with the institution or the organization. And I think we just heard about that and how this happens in charities in Linda's talk on the previous session. And it'd be great to hear more about that actually, because I know we ran out of time there. So by difficult, and we've put difficult in these quotation marks deliberately then, we mean a mental health experience that is disrupting someone's everyday life. What might be marked, therefore, as a crisis. So everyday tasks that were once more simple to do now become difficult or impossible. Perhaps the loss of commitment, so employment or relationships, and threatening or doing violent behavior to themselves or to others. And this use of quotation marks is to call into question what it means to be difficult, to stick out, to cause a problem, to get in the way, and then how that is responded to. And that's an integral part of understanding how people whose minds become difficult are then treated. Have the next slide, please, Jenny.
Yeah.
So we should also define what we might mean by carceral approaches. Alexander defines this as, quote, the ideas, beliefs, and practices teaching us that punishment is the only way to deal with societal harm. And on the slide to the right is the front cover of Liat Ben-Moshe's Decarcerating Disability, which some of you might know. It's a well-known book that offers a really useful in-depth examination of carceral approaches to mental health. And Ben-Moshe makes the compelling case that incarceration, of course, doesn't just affect everybody equally. We know that most people in prison have been made poor, have been made disabled or identify as disabled, and are people of colour. So, in the context of mental health, carceral responses might look like being beaten, tasered, arrested, or subdued by police if you're in a mental health crisis and public. Being in the presence of securitized nurses who wear body cams and are trained in physical restraint, often on secure mental health wards. Of course, being incarcerated in secure mental health wards, being sectioned temporarily or longer term with no end, being forcibly medicated. And we're also making the case here today, using our case study, that it can also be when someone's everyday life is controlled and carceralized. So being forced to live in particular places, being hyper-monitored, being surveyed, being recalled at any moment. And this is the so-called rights-based framework of care in the community. Can I have the next slide, please, Jenny? So before we come to our case study, we're just going to briefly contextualize it within the broader deinstitutionalization of mental health care in the UK. On the slide, there's a graphic, which is meant to be funny, depicting the process of deinstitutionalization. And it's got three doctors in lab coats saying that they have a plan to save even more money, and the more is emphasized. And they're stood in front of a red notice board that has a flow chart showing the movement of patients from state mental hospitals to jail, homeless shelters, private hospitals, nursing homes, and dumpsters. And the graphic essentially illustrates how in the late 1990s, under Margaret Thatcher's government, there was an aggressive and persistent shift towards this structure called care in the community. And it was purported to be due to a moral shift, seeking better treatment of people with severe mental illness, acknowledging that asylums were harmful places. But it was also to do with developments in pharmaceutical treatments that actually enabled care to be undertaken away from hospitalized settings, and was part of a broader shift towards neoliberal decentralization of power and privatization of state institutions. And in his chapter in Mind, State and Society, Scull describes this in the following way, and I'm quoting, welfare reform in Britain, as in the United States, has become a term of art disguising repeated assaults on the social safety net and the demonization of those dependent on it. Community care in the era of neoliberal politics has turned out to be an Orwellian euphemism, masking a nightmare existence for all too many of those afflicted with serious psychoses and their families. So using our case study, which I'm going to explain now, and our examination of CRPD, we argue that care in the community enables the extension of the carceral state into people's everyday lives in neoliberal ways that actually harm people in need of care and harm communities. So next slide, please, Jenny. So our case study is on community treatment orders, or CTOs, which are used in the UK. So I'll just describe what they are and offer some background and context. So they're introduced in 2008 in England and Wales, and they are the legal means through which people living with mental health difficulties can be made to accept treatment whilst living outside of the hospital. So a CTO can be ordered by what's known as a responsible clinician. That could be a doctor, psychologist, a nurse, occupational therapist, and even social workers. They can last up to 6 months, but they can be repeated as many times as deemed fit by that responsible clinician, and they can only be challenged by the person under the order at a mental health tribunal. And they're issued to people sectioned under Section 3, Section 37, and Section 47 of the Mental Health Act, which I won't go through in big detail, except to say that, for example, Section 3, you don't need to have had a criminal conviction. And I think also with Section 37, you don't need to have had a criminal conviction to be put under one of these orders. And they involve compulsory conditions, such as restricted travel, being forced to live in a certain place, being sober, attending compulsory appointments for treatment, and being forced to take injections and medication that have actually been proven to cause other kinds of health issues. And if somebody refuses or fails any of these conditions, then they can be taken forcibly back to hospital by the police at any time. And we'd be forgiven, for looking at this list of conditions and thinking this is someone who's been found guilty of a criminal offence. But like I say, Section 3 and Section 37 don't necessitate any guilt, and not that these are appropriate even if somebody has been found guilty of something. So instead, we see a list of conditions that are most definitely carceral as a response to mental health. They're also, to an extent, self-perpetuating. So if somebody improves according to the responsible clinician, then the CTO looks to be working, and then they're more likely to be kept on it. And research has clearly shown their ineffectiveness, yet they persist quite significantly. So the next slide, please, Jenny. So in the last year, 5,618 new CTOs were issued and 109 people were detained indefinitely after their CTO was revoked. And I'm about to hit you with loads of numbers here, so just bear with me. So this is the use of CTOs is highest for Black or Black British people. It's 7 times the rate than white demographics, which mirrors how mental health is policed more broadly, whereby people living in deprived areas are 3.5 times more likely to be detained. Black people are 3.5 times more likely to be sectioned than white people. And actually, last year, white people were the lowest ethnic group to be detained at all. And those are statistics from NHS England. And some further statistics that reinforce that are from Misha Fraser Carroll's excellent book, Mad World. So Black people are 40% more likely to make contact with mental health services through the criminal justice system. They're more likely to be secluded and restrained on wards, disproportionately likely to be on a medium or a high secure ward. Black men are 10 times more likely to receive a diagnosis of psychosis than men, and in particular, Black Caribbean people are disproportionately likely to be diagnosed with schizophrenia. So alongside these quite horrific statistics, there's quite a clear presence of the impulse for the neoliberal self to self-manage under a CTO or be subject to disciplinary control. So while they might appear to be part of allowing people certain freedoms within community spaces, baked into them is a forced choice where you can allegedly freely choose to adhere or you just get returned to confinement. So we view this as an expression of a combination of governance, whereby we have disciplinary, carceral, and neoliberal techniques all working together as mechanisms of control to manage difficult mental health. And it's very clear that the so-called care based in the community is actually indicative of reforms that proliferate and spread the reach of the prison outside the formal site under the guise of gentler community-based responses. And we might mirror this with other types of community-based responses like probation orders that appear to be about rehabilitation and respecting the rights of the individual, but in reality spread the carceral reach. And to be clear, this reach, as we know from Ben Mush's work, but in general, impact marginalized subjects the most. So we might say that challenging and managing difficult mental health requires a special approach, but as O'Loughlin and Payne note, quote, special treatment can all too readily become special control, and to be seduced by the notion that risk can be managed through the containment of identifiable individuals is to allow discriminatory treatment whilst failing to tackle the roots of the problem. So a natural impulse to this might be that we need more rights to protect those persons who in this example are having their rights infringed, but actually we think that this example quite clearly demonstrates the unequal application of rights. If you're too mad, you forego rights, showing that there are special exceptions to rights. And this idea of special treatment for special cases is equated to special control as an upshot of rights. So I'm going to pass back over to you, Jenny.
All right. So before we get more deeply into our argument against rights, I think it's worth sort of pausing to ask or just get clear on why do we appeal to rights and why do we look to rights as sort of a solution to various social ills and problems of violence and discrimination. So Alan Hunt, who was a Marxist legal scholar, has pointed out that the aggregate effects of law in modern democratic societies work to the systematic disadvantage of the least advantaged social classes. And the practice of law constitutes an arena of struggle where we fight perhaps with the ruling classes over resources and allocations of rights and privileges, which Hunt puts as relative positions and advantages changing over time through legal struggles. So I'll read this quote where he says, claims capable of translation into a discourse of individual rights and those interests congruent with existing rights categories are most likely to succeed than more likely to succeed than claims not matching these characteristics. So we tend to sort of funnel our demands into this rights language because historically, perhaps they're more likely to succeed in law as a terrain of struggle. However, so social movements also understand and engage with concept of rights and how their understandings and engagements ramify certain types of practices for social transformation to bring about a just world. But as legal scholar Rada D'Souza points out in her 2018 book, What's Wrong with Rights, there is a conflict between the normative idea suggested by rights, that is, like what we think of rights as doing in the world, and on the other hand, the institutional realities ramified by rights today. D'Souza argues that social movements' understanding of the place of rights in capitalist and imperialist relations is an important reason that social movements, quote, give away with one hand what they wrest with the other. So how does this work? And I'm going to try to show maybe how this plays out with the CRPD as our second case study. So as Lizzie pointed out, we might think that fighting for more rights might be a solution to the sort of abuses and rights violations that CTOs bring on. So I know the last talk also talked about the CRPD, so please bear with me if this is a bit of overkill. But I'm going to reintroduce the Convention on the Rights of Persons with Disabilities. It was adopted in 2007 and has since been ratified by 177 countries. Importantly, not the US or the UK. The CRPD was thought of as a big sort of victory for psychosocial disability advocates around the world, as it represents a paradigm shift from an impairment-focused biomedical model of disability to a socially focused, human rights-based model. Importantly, Articles 12 and 14 of the CRPD have asserted the right to equal recognition before the law. So equal rights for persons with psychosocial disabilities. Article 14 also asserts that persons with disabilities should not be deprived of their liberty unlawfully or arbitrarily, and the existence of a disability shall in no case justify detention. So this has been interpreted to mean that Article 14 basically makes any kind of forced treatment or incarceration based solely on someone's disability unlawful. So what impact has the CRPD had on signatory states, although we mentioned the UK and the US have not signed it? One example, it has been adopted by a signatory in the Indian Mental Health Care Act of 2017, which was drafted because, quote, it is necessary to harmonize existing laws with the CRPD. Similar processes have taken place or are in motion in 32 other signatory countries. So there is an effort to harmonize national and state mental health codes with the CRPD, which appears also to be a step in the right direction. So, so what is our problem with this? So Article 12, which I mentioned a couple slides ago, was sort of a response to biomedical approaches to mental health that have allowed for something called substitute decision making. So when someone is judged not to be able to make decisions for themselves, a proxy person comes in and makes decisions for them when someone else has deemed them to be, quote, incapacitated. This, according to advocates, has led to considerable maltreatment and abuse of people with psychosocial disabilities. And so with this history in mind, advocates that were pushing for Article 12 to be adopted as part of the CRPD, including the World Network of Users and Survivors of Psychiatry, argued strongly for the right to equal recognition before the law, and this is how we got Article 12. The general comment, which is, sort of more text that is supposed to help us interpret this article, affirms something called universal legal capacity. This means that all people should be treated as having equal decision-making competency at all times and mandates a regime of supported decision-making, although there's a lot of disagreement about what supported decision-making means, in which an individual's will and preference are sought in matters regarding treatment, and assistance is provided to make it possible to ascertain your will and preferences. The general comment also says that Article 12 requires recognition of equal, quote, personhood, unquote, of people with psychosocial disabilities, regardless of their level of cognition. Okay, so in a study performed by someone called Justin Carter, who teaches at the University of Boston now, so in his PhD research, he interviewed a bunch of psychosocial disability advocates that were involved in the fight to get the CRPD ratified. So his research, I'm just going to read some quotes from it, from what he found interviewing people like who had worked to get the CRPD, and specifically Article 12 included. How they were responding and reacting after the CRPD had been ratified. So following the adoption of the CRPD, these regional groups with lived experience of psychosocial disability were organizing politically to leverage its guarantee of rights, that Article 12 universal legal capacity bit, to contest psychiatrization, or the medicalization of mental distress and its effects on persons with psychosocial disability. So according to Carter's study, these efforts were often co-opted by powerful actors. So one participant said, quote, "In these institutionalized spaces, people with psychosocial disabilities are seen only as an endorsement. They care about our testimony, not our participation in any active way that could lead to transformation. While we might be tempted to call for more rights and more protections in response to infringements of those rights, D'Souza, who I mentioned earlier, points out, and I think this example also suggests, that rights don't actually do the things in the world that we necessarily want them to. Why is that? I'll talk a little bit about it in a second. If we had different and better institutions, and this is sort of my hypothesis that I'm putting forward, that I think is in line with what D'Souza is arguing in her book, is that better institutions and better institutional practices means we actually don't need to talk about rights. So one example of a institution that is just practicing anti-carceral mental health care is something called the Runaway House in Berlin, and I'll put a link in the chat once I'm done sharing my slides, so you can look at it if you like. But I think overall, and I'll talk about a couple other examples, but I think overall a focus on redistributing resources towards building these institutions that and oftentimes are already there to do the work that we like and that is anti-carceral, is better and perhaps more effective than focusing on rights as a panacea. And I'll hand it back to Lizzie now.
Thank you. Yeah, so in terms of thinking about how else we can manage, quote unquote, difficult mental health, so it's important to recognize that a lot of mental ill health originates in trauma, whether personal trauma or intergenerational, cultural, structural, and familial trauma. And responding to how we manage difficult mental health is also therefore about earlier intervention to prevent it happening in the first place. And we don't mean early intervention like early psychiatrization or early contact with mental health systems. And like I mentioned with co-production, early intervention is a bit of a buzzword at the moment in charity sectors. Rather, using a structural approach, it's about putting in place better funded communities, better material resources, dealing with family harms better, dealing with structural harms, preventing cycles of trauma, etc. And again, in agreement with the previous paper from Linda on the previous panel or session, charities, I think, are also not the way forward here either. So in terms then of when the crisis has happened, there are plenty of organizations already doing this alternative work. And certainly Jenny and I are not claiming that any of these examples of work that we've come up with. There is a lot of this already happening, as I'm sure many of us know. On the right-hand side of the slide is a poster for Mad Pride from 2023, which was held in London. It's got a pink and purple background and some artwork that is basically about accepting and madness and refusing the institutional discrimination against madness. As well, NSUN and Act Build Change created alternative safeguarding practices called The Shape of Safety, which is aimed at changing how practitioners respond to young people with safeguarding. Campaign for Psych Abolition, CPA. They've developed how-to guides for self-care crisis plans, but also how to intervene safely if we see someone in crisis without calling the police. Recovery in the Bin is a survivor-led network that campaigns against notions of recovery as a linear institutionalized term. And what's important about all of these approaches, what they have in common, is that they're based in a fundamental acceptance of the principles of agency and autonomy, where the person in crisis is given the information and care they need to decide. They need to decide what they want to do rather than looking at a rights-based framework. More generally as well, we're arguing that there needs to be a concerted effort to decenter the neuronorm and resist the neoliberalizing of mental health. That's fairly obvious. And framing and viewing mental health through capitalism, that you're only well if you're productive. So this idea if somebody does lose their job, it's indicative of, a crisis, not necessarily, maybe they just don't want to go to work anymore, which is fair enough. Alongside this, we obviously things like widespread education about what mental health and mental crises are and the unlikeliness of violence. And, that's where things like CPA's how-to guide on how to intervene safely is really important because often people will respond with fear because of how mental health is communicated in everyday media. And whenever I'm talking to students about this, I always remind them of the statistic that you're more likely to be struck by lightning than you are to be harmed by someone with a diagnosis of paranoid schizophrenia. And it always seems to blow everyone's minds because we're constantly bombarded with this imagery that if you're not well, you're always already violent. But despite this, despite sharing this knowledge, people, as we know, mad people are avoided and shunned in everyday life and in communities. But also, even when people are willing, it's quite clear we don't have the community material structures to intervene. And we're arguing that we can't look to the state to do this work. Instead, we need to identify what is needed materially to do this work. And Jenny's going to take us through some research that does just that.
Yes. So a few years ago, another colleague of mine and I interviewed five people from five different organizations that were already doing the sort of work that we identified as anti-carceral. So these included something called the Parachute Project in New York City, Trans Lifeline, and the Sunflower Alliance. And these are all United States-based organizations, which is, as you can probably hear from my voice, where I come from. So in interviewing these respondents, we noted three common barriers to performing the work that they did. So in the top one that was identified by all of our participants was an economic barrier. So nearly all of them, I think it was all of them actually, that's a typo. They identified economic barriers as a major deterrent from doing this work, including limited funding for non-coercive care, innovations and techniques, institutional funding requirements that perpetuated systemic problems. So this is when they got, say, a grant or they were funded through some larger institution, and the grant would come with strings attached that would perpetuate systemic problems in crisis care. Attempts at scaling up care with limited resources was also identified as a barrier. So these organizations tended to start small and stay small because there was no way to get sort of adequate funding to increase their range and their ability to provide services. And finally, the tensions between funding and integrity in community care. So there's always sort of that trade-off between trying to fit yourself into the mold of what a funder is looking for in order to give you money to do the work that you want to do, which is sort of outside of the mainstream norm. The other barriers that they identified were co-optation. So again, sort of being sucked into or co-opted into a larger institution that didn't share their values. These participants identified a clear tension present in almost every interview that we did, around ongoing engagement with formal systems of care, like psychiatric hospitals, despite having knowledge of the various ways that this form of support was harmful. And finally, they identified difficulty engaging stakeholders. So accumulating volunteers, sustaining community interests to grow programs, and achieving consensus among stakeholders regarding policy decisions. So the takeaway, I think, from this is that we have, like, these organizations already exist. What they're asking for, or what they're identifying as barriers to really doing their work, is having enough money and autonomy to build the infrastructure and community. Not a single one of them notably identified rights as something that we are lacking or missing in doing this kind of work. And I think I'll hand it over to Lizzie after this just for closing, but I'd like to read this quote from Rada D'Souza, who I've mentioned a couple times before. That might be a good place to start our Q&A afterwards. So she says, I think we are kind of trapped in this whole discourse of rights as the only way to imagine freedom, so much so that we are not able to imagine what real freedom will look like. And that's the big difference between anti-colonial movements and our times now. We don't see the colonizers of our times, although we can see that the US wages war, there are rendition flights. We are not able to put those things together and see imperialism or colonialism as the main problem. Instead, there is this idea that we can change something with our leaders or within our nation states, and that becomes freedom. Rights become a substitution for freedom, and I imagine most of the time when people say they want the right to this or that, what they are asking for is freedom or emancipation. So why don't we just say we need freedom? One of the reasons we are not able to reimagine this is because we have forgotten our histories. And Lizzie, did you want to say anything in closing? Okay, thank you so much for listening, and we welcome your comments and questions.
Amazing. Thank you for such an excellent presentation, both. We've got now a couple of questions. I've received some questions directly via messages, but I will start with the public ones in the Q&A. The first one is a message with a comment. Thank you for this clear inquiry into the carcerality of mental health practices. The clear cognitive bias of psychiatry and mental health practices and systems is a powerful evocation of epistemic justice in how mental health services historically and still larger inequities through containment, maintenance, and compliance. The fact that mental health law has less stringent rules of evidence or procedure than criminal law guides us to see that it's not rights at all. So that was the first message. And then there was a comment that the UN Convention on the Rights of Persons with Disabilities, the CRPD, has been ratified by the UK in 2009. But hasn't been turned into law, I guess was the suggestion. So those were comments, and I'll also move to some questions. So I am convinced, so question from a participant, I'm convinced by your claim that a fundamental alteration to institutional systems is fundamental to overcoming the repression of distressed people. I'm struck, however, that much of your focus is on bottom-up institutions, which could better manage support. I was wondering if you could say a little more on the incentives of the broader institutions, i.e. police, courts, hospital systems, funding bodies, which enforce carceral systems. Why are they committed/tolerant of the current system?
Do I go first, Joey? We are muted at the same time.
Do you want to start?
So if I'm understanding the question correctly, is it asking why are the kind of top-down, I guess, institutions that enforce the carceral systems, why are they so committed and tolerant? Yeah, well, I guess because of, well, carceral mechanisms themselves work to consolidate power and consolidate and uphold particular structures. I mean, our focus is not on them because I think that that is also more of a reformist argument, which I don't think that we're making. Well, I know that we're not making. I don't think that you can reform a secure mental health ward or the whole system of secure mental health wards to make them less damaging and less harmful, because inherently they were, and if we follow feminist abolition, and what that teaches us, they were designed to always kind of warehouse and harm and remove particular types of people out of society and exile them out of society. So I don't think that our attention is best focused towards those bigger institutions, and they are invested in perpetuating that harm because of power, because that's kind of what, to a certain extent, that's what, we're used to. That's the institutions, they are self-fulfilling, they continue, they go on, and unless we do something about it. And I think that in terms of actually affecting change, in my view, yeah, we're not necessarily, I mean, in the short run, for sure, we can improve people's experiences within mental health wards. We can improve people's experiences when they come into contact with police or whatever. But at the end of the day, they're still getting locked up on a ward and forced to take medication. And that is not actually going to help in the long run, in my view. I hope that answers the question and that I understood it correctly.
It would just, yeah, I don't have really much to add other than I think that the question also mentioned funders as someone that we might try and reform. And I would say that I have not given up on funders or private foundations specifically. Like, I think that there is like some political education work that we can do in those institutions. And there's a lot of evidence that like these kind of small upstart bottom up providers are doing a lot of good and have been successful on their own terms. So that's one area where I have not given up, but obviously we didn't really focus on it in our talk. Thank you.
Thank you. I have two more questions. Let's go through them in order, just one question and one answer first. So, great presentation, thank you. And I was particularly struck by the ways in which you highlight the nexus of disciplinary, carceral, and neoliberal techniques working together. The care in the community shift at the same time as marketized treatment, psychiatric, was also really interesting in thinking about how mental distress has been marketized. So a question that this participant would like to ask is, what might better institutions and institutional practices look like in the context of CTOs?
Thank you for the question. Yeah. I don't think that, I think maybe, I don't know, I'd be interested to hear what Jenny thinks here in terms of the institution, but perhaps it comes across as kind of too, I don't know, extreme, but I just don't think that institutions, first of all, I don't think things like community treatment orders can ever be implemented in a non-harmful way. It's all like they are fundamentally rooted in carceral techniques, and I don't think that the institutions that we have and the way that we are used to institutions running can be reformed to the extent where they're not just going to be doing the same thing in a different way. I struggle to kind of believe that. And I think that the response to that is we don't just kind of say, oh, well, they're not working, so we'll dismantle them. We're also having to build new things at the same time, irrespective of them, so that people don't come into contact with those institutions and instead are kind of protected from the harmful state. But yeah, it is thank you for highlighting the care in the community shift and the marketizing of mental health distress as well. And as a kind of side, it's also quite interesting to think about how like allegedly okay it is now to talk about mental health and how it's being capitalized in a different way. But it's only particular types of mental health, because when you see those adverts where it's okay to talk, I'm not saying it's necessarily a bad thing. Having bigger conversations about mental health is important, but it's particular presentations of mental health, while some, persistent quote unquote disorders are still not being engaged with the market. They're still kind of demonized and disciplined. Yeah, that's a bit off-piste, but just what that question made me think of. I don't know, Jenny, if you've got anything in terms of institutions.
I mean, I would say, maybe, well, the way I interpreted the question was like, if we have these sort of better grassroots treatment centers and providers, why couldn't we just change community treatment orders to say, okay, you have to go to one of these? But I think the problem is, entrenched in the model of the treatment order itself, which is not that someone should seek treatment, but that there's the threat of violence and incarceration lying behind if you don't do what the court has told you to do. So that's all I wanted to add.
And I think we also have to be cautious of institutions absorbing grassroots practices. Like we increasingly see the use of restorative justice by the prison system. That isn't a good thing. That's just further cooptation and like the rampant kind of spread of that. So I would want to keep things very separate.
Thank you very much. Next, I've got some other questions. What risks might we run by dispensing with rights without dismantling the neoliberal context under which they arose as the main form of contestation? And I'm trying to figure out if the next question would be very different. Well, I'll just ask the next one as well, in case, because they're quite linked. Can anti-carceral challenges also challenge disciplinary and neoliberal technologies of governance?
So, I'm still unmuted. So, for the first question, I think it's a really good question. Like, what risks do we run if we sort of give up on rights and focus on something else? I mean, and that's a question that I'm still sort of grappling with myself. I don't think that, like, I do think rights have instrumental value, or they can have instrumental value, but it's all about how they get sort of enforced and institutionalized. And so if you don't have the resources to, say, hire an attorney, your rights don't actually mean a whole lot. So I think that it's not a either or right now. I think it's a both and, but I think we need to also recognize that the extreme limitations of rights and how they are tied to access to wealth, for example. Yeah, Lizzie, did you want to?
No, I agree. Would you mind repeating the second question? Sorry, when I can't see the questions, I just
Of
completely lose
course.
track and I will go off.
Yeah.
The one about anti-carceral challenges.
Can anti-carceral challenges also challenge disciplinary and neoliberal technologies of governance? And then they also asked, what are the processes through which this nexus of techniques functions?
Those are two huge questions.
Yeah. So, shall I go through the carceral one?
No, it's okay. I can, I'd be interested to hear what Jenny thinks as well. I think the anti-carceral challenges can certainly challenge neoliberal and disciplinary techniques of governance and technologies of governance. At their core, my understanding is they are kind of community-based, and that doesn't necessarily mean, sometimes people feel, if we're in community, we will have to get on and like each other. And I think it's really important to acknowledge that, we don't actually have to do that as part of these modes of resistance. We don't have to get on. And the community doesn't have to be this kind of imagined, like, happy space of everybody in agreement. But what bringing together and focusing on community does, particularly in terms of neoliberalism, is refuses the politics of scarcity and undeservingness and deservingness, and instead highlights where like the real threat to people's welfare is coming from is not from, each other's competing rights, but is actually coming from a broader framework. So I would say in that way, anti-carceral techniques are very compelling. In trying to kind of resist that inherent competitiveness of neoliberalism. I don't know if you have anything to add to that, Jenny.
I could not add anything better than what you said.
Thank you. The next question is, what, if anything, do you find to be the most promising developments within legal studies and legal practice that could be used as challenges to the current neoliberal context of individualism and rights?
That's a really a very interesting, very big question. I don't know if I will give a very good answer. I mean, it's something I think about a lot. So I think there's maybe under considered legal mechanisms that we have other than rights litigation, or even so the class action, for example. So you can use a class action to vindicate rights, but it has like a collective sort of force to it because a class action has, instead of an individual plaintiff, which is very neoliberal individualistic, we can have a whole class of people. Like every person who, like if in a consumer rights litigation case, you might have heard of like everyone who used this cell phone could be a plaintiff in this class action. They could be a member of the class. And so it's a way where there's a very widespread harm, but it might not be like a huge harm, or the individual plaintiffs might not have resources to each hire a lawyer. So one lawyer or law firm can come and represent all of them and leverage all of their injuries against the wrongdoer or defendant, right? So you can have a class action against the state, for example. There have been a few of these, like in the United States, against the police or against prisons and things like that, contesting conditions of confinement or unconstitutional police practices. I'm sorry, I'm speaking in the language of American law. That's just where I went to school. So that's one. I think maybe like it's obviously used a lot in some contexts, but I think it is a legal mechanism that sort of de-individualizes the way we think about ourselves as legal subjects, perhaps, because like being a member of a class. And that's all. Yeah, I mean, I don't think there's a lot really, but I think there's some interesting stuff to do around like uh, tax law and policy, but I don't think I'm going to get into it right now. But thank you for the question.
Lizzie, would you? Okay.
I know nothing about the law, so I'm gonna pass.
Thank you. I have one other question. Class actions also rely on and exist within legal systems. However, and available relief might be understood as harm reduction or compensatory in nature. The question is it possible to engage with law without reinforcing the legitimation of legal systems and the state?
Again, a big question, and lots of smart people disagree about this. I think that so one way to engage with law that isn't sort of focused on monetizing harm and getting individual damages is the injunction, which basically says stop doing that, right? It doesn't say you owe me for this, or I'm going to put this dollar or pound amount on the injury you've done to me, but actually you have to stop this practice that is harmful. Now I'm just talking and I've forgotten sort of the question. Will you repeat it to me once?
Sure.
Thank
Is
you.
it possible to engage with the law without
Mm.
reinforcing the legitimation of legal systems and the state?
I mean, yeah, as I said, I think a lot of people disagree about this. I personally think that, as someone that has practiced law, it hasn't re-legitimized the state for me. Actually, it's done the opposite. And so, take from that what you will. I'm sure a lot of other attorneys have had that experience. I see the law as a tool and not necessarily something that has to reify the state, but a lot of people I respect disagree with me. So I'm fine if you disagree with me too. I think of the law as being like money, right? We can't just stop using it, right? It controls our lives in many ways, and it's useful to know about and be able to use it. Whether or not you think it's ultimately emancipatory, probably isn't, but neither is money. So, yeah, I'll stop talking. Thank you.
I would just add to that as someone that has not practiced law, I think that there might be a kind of an opportunity to, well, I guess there's a temporal component to it in terms of short-term and long-term strategies and goals. And a question that I sometimes think about is, and I think it's a really interesting question, what's been asked is, can we use the law, like aspects of the law strategically to further goals that are not necessarily then law-based or reformist? Like Jenny says, that's a really contentious and difficult question. And I think it just comes down to case by case. it depends on my mood on the day, if I'm honest, whether I'm like, screw this, I'm not getting, or actually there's aspects here that we can kind of take and run. I don't know.
Thank you. I can see a raised hand. Danny, would you like to ask a question? And then we'll wrap up. If the question could be brief, that would be appreciated.
Yes, thank you. There's so many things to say about this topic, and I appreciate the complexity and nuance you both bring. And this point is really interesting. And I love how Jenny used the language of both and, right? That there's as somebody who works in disability advocacy and I do special education policy, so I have to work with and through law very frequently and work with schools and address parents. Hi, my friends, parents and schools, and have conversations about disability rights and special education law within schools, knowing that the policies, the laws, the systems and structures are inherently dysfunctional. They are not designed to be liberatory. And we have to use them in the best way we can as we move forward in building better systems. So I think it's like both and. We can't get to that emancipatory state unless we address where we are currently. I guess that's more of a statement than a question. But thank you guys for bringing everything you've discussed.
Thank you, Danny. Yeah, I mean, I think I used to be a special education teacher, and I think that's a great example of where, you navigate with rights and you advocate on behalf of children to get what they're entitled to under the law, even though you know that it's not enough and you know that the law is harming them in other ways as well.
And special education is inherently ableist. It's not what we want.
Yeah.
Right. Yes.
Yes. Absolutely.
Amazing. Thank you very much, all. That brings us to the end of this session, as unfortunately time is running out. I'd like to extend a huge thank you to our presenters of this session today, Lizzie Hughes and Jenny Logan, as well as to our BSL interpreters who have worked tirelessly to make these sessions accessible. Finally, a big thank you also to our tech support colleagues for facilitating these sessions. We will now take a 15 minutes comfort break, and we will look forward to seeing you all back here for the next session, which is on mobilizing rights, building movements. Thank you. So we'll be back at 15 past.
Thank you. Thanks for sharing, and thank you everyone for your contributions. It's really going to help our piece of research, so it's really appreciated. Thank you.
Yes, very appreciated. Thank you.